I'm Marcus Hutton, actor for 40 years and voice artist for over 30 years. I'm also chair of the Equity Audio Committee, and I've been advocating for performers' rights, particularly in the AI space, for the past few years.
I'm Dr. Mathilde Pavie. I'm a lawyer and an expert in intellectual property, AI and ethics.
I'm Annette Rizzo, a broadcaster, university lecturer, voiceover and activist of long experience, but rather lighter on legal expertise. It's my job to ask the basic questions so no one else has to. You're welcome.
Welcome to the Last Human Voice podcast, exploring the moral, legal and ethical issues in artificial intelligence in the creative sectors and in performance synthesis.
We'll be focusing on the legal rights and protections available to artists and performers.
And looking at how AI affects us all, down to the very last human voice. This time it's 101s from The Last Human Voice. Bit of a shorter episode, and we're talking about performers' moral rights. What are they, and why should we care about them now?
Now, moral rights are often mentioned, but they rarely seem to be well understood by performers or by engagers.
We expect that moral rights are going to start coming up more in our conversations with future guests, so we thought it was a good idea to hit pause and have a little chat amongst ourselves so that we and you are all on the same page. Now, Marcus, I'm going to take a little punt here that moral rights have been on your radar for longer than they've been on mine.
Well, they have, because they've always seemed a bit strange to me. I mean, I know, I know they exist and they're there for a very good reason, but because in our contracts they're the first thing that gets automatically waived, it's always felt like, well, what are they there for? If you can't apply them, what are they there for? But then I discover that's not always the case, depending on the country. Mathilde.
Yes, they do vary, and actually the history behind moral rights and how they came into law has a lot to account for the fact that there are differences in moral rights protection from country to country, but also good news, there is international harmonization, which means that we do have a common frame to work with and to operate on cross-border, so that actually more rights are known and found in more jurisdictions than not. And we'll get into the details of that in a minute. But what struck me when I started working closely with the creative industries and performers and engagers in particular was how moral rights were perceived in the field, and some of the misconceptions, of course, but also the difference between how lawyers understand moral rights as this add-on or bolt-on to performers' economic rights, as kind of unproblematic and pretty straightforward in what they mean and how they operate, versus the reality or the experience in the field with more rights to be turning them into more of a anti-creativity monsters where they're not. And I think it's worth having that conversation to debunk a couple of myths on that topic, I think.
Well, I think first we've actually got to establish what moral rights are, because as Marcus said, very often they're in contracts. And I'm a little bit embarrassed to say that it's really only in the last few years that I think it probably have had the confidence to actually read my contracts in any great detail, because you get them through and there's two things. One is that you kind of think, well, I have a choice, which is either I sign this or I don't get the job, which isn't always true, which is one of the things I've discovered by actually pushing back against them, gently and politely, but pushing back. And the other thing is that you kind of think, well, you see, again, I think I've said before, this big wall of words. And I've looked at contracts and thought, I don't know what I'm doing. I don't know what a lot of the legal jargon means. I can parse out the meaning from these sentences, I think, sentence by sentence, but I don't have the confidence to really feel that I know what I'm doing when I either accept or reject. So can we go right back to the beginning and say, what are moral rights?
Absolutely. So moral rights, whether you're looking at international law or national law, refers to two rights. The first right is the right to be attributed as the performer in the performance. And we can call that the right of attribution or the right to be credited. It's all fine. It's all phrases referring to the same protection. The second right is the right of integrity. And that means that you can object to your performance being modified or mutilated in a way that would be detrimental to you as a performer, and more specifically detrimental to your reputation as a performer. So we have the right of attribution and the right of integrity.
I think it's the right of integrity that probably makes me most anxious. And I think one of the examples of a recent one, some in the last sort of year or so, was a company that I actually genuinely think was trying to do the right thing, that approached me and here we go, wanted me to sign up so that they could use my voice, make an AI avatar of my voice, and that then they would sell that or hire it out, and I would get a royalty from that, a very small royalty. One of the problems I had with the contract after taking it to equity and talking to Marcus about it was that although I was effectively handing them my moral rights, and their response to me was, well, don't worry, because we have a clause in our contract to clients that says when they purchase the voices, they cannot be used for X, Y, and Z, all the things that would worry us most. Um, the next question was, how do you monitor that? And there wasn't really a very robust answer. So I was trusting them by saying, sure, I'm waiving my moral rights because I believe in your second down the line protection on my behalf. But once it leaves, I don't know where that's going, but neither do you. You know, you can say you can push back against your clients if they break that contract, but you've got to catch them breaking the contract. And so, funnily enough, I didn't sign.
And so, what you're describing here is actually several steps in the scenario you've described. You had a contract that asked you to waive the more rights in the first place. And so that your client could use your voice in a way that I suppose is freer to them. But at the same time, I I guess deduce from what you've described, they contractually committed to you to respecting the integrity of your performance, even though they've just asked for a waiver of the more rights. And then obviously you've tapped into a real vulnerability of performers, whether you're thinking about more rights or other rights, was the fact that you may have all the rights in the world and your clients may respect them, but what about third parties' behavior? Either there are people that make that they give or make your work available to, or there may be completely third parties who may come across the work online without having even terms and conditions, or purchased a service or a product with your client. And this is where, like the last point, that vulnerability is something any legal rights you're given or you come up with will have, because there's only so much the letter of the law alone and the letter of a contract can deliver in practice. So that's why we often refer to the best protection being a combination of both strong rights and strong means of enforcement, as well as sort of technical solutions to prevent use and misuse and abuse as well in the wild or on the internet, for example. And without that comprehensive approach, it is true that the best more rights in the world, the best contract, is not going to deliver on day-to-day real practical protection. But we've gone quite far down. It's quite an advanced take on more rights already.
Yeah, I mean, I guess the history. Well, I mean, you can explain what the history was, but moral rights didn't seem to matter very much when you were doing a commercial or a film or whatever, and you could sort of see why waiving them was necessary because if somebody doesn't want to spend $50 million on a film and then have an actor, a year down the line say, actually, I want to withdraw my performance now because yeah, I morally object for whatever reason to what you've done in the film. So that's why we're asked to waive them. And so that was sort of understandable. But now with AI, where a derivative work can be anything, it can be hate speech, abuse, porn, whatever, frauds, scams, moral rights have really snapped into focus. So maybe, well, I suppose firstly we should ask, who gets to have or receive moral rights? Who is it that benefits from them?
So it's really interesting that you raised the point of waiving more rights being understandable, because it could be a bar or a barrier to exploiting or commercially releasing the work later down the line after a lot of investment has happened, etc., because actually that's part of the misconception of moral rights. But first, let's start with who gets
Ah,
them, and then we'll get into the scope of the protection, because legislators have thought about the scenario or the hypothesis you're talked about in terms of we don't want a performer coming up, 2 years down the line after millions are invested to block a project. So who gets more rights? If we look at performers, anyone who receives performers' rights in the first place will receive more rights as well. The right occurs or is eligible. Sorry, the right occurs and applies in tandem with your economic rights. And you are a performer if you are interpreting a work, an artistic or literary work. So the definition is quite broad and will certainly cover all and most performance work that you're doing as a professional or as an amateur. So who is a performer is not so much of a problem. The next question is how do you receive or exercise your moral rights? So by receiving performers' rights, which occur naturally, you don't need to register your performance anywhere. You receive also more rights protection. Now, the slight formality you need to do in order to exercise your moral rights is to assert them. And that means that somewhere in your contract, in your official website, in your email, you need to say that your name, I assert my moral rights. And that will mean the application automatically applies. No need to go and complete and file another form and submit it anywhere or register any other right. You need to have that line inserted, and you need to make sure your clients are aware of that line because it's in your email signature, in your contract, or available on your website. And that means anyone coming across or in contact with your work and with that little notice will be bound to respect your moral rights unless you've waive them later, and you may on a project by project basis, for example. Now, what more rights come with, very importantly, is an exception. So you receive a right to be attributed as a performer, and you receive a right to object if your performance is distorted in severe ways, so much that it would impact your reputation as a performer. Usually, if it's distorted to make you sound poorer than you actually sounded because of a tech modification or something like that. Now, the law has baked in exceptions to make sure that performers can't abuse the right in circumstances where it would be unreasonable. So, for example, the law provides that your performance can be modified in line with common routine and editorial practice. So, translating your performance into another language, for example, is not an infringement of your moral rights. Of course, you need to have been asked and given permission for that not to be an infringement of your economic right. But if that permission is given, that use is authorized by you for translation, it won't trigger or impact your moral rights to integrity by having the work translated. Another example, if your work needs to be edited, shortened, make the speech a little faster to fit in the radio slot that the advertiser was given, then that also will be regarded as routine and not prejudicial to your reputation. So we're really looking at extreme distortions or modifications of the performance that wouldn't be expected or common. And in practice, that means that actually most engagers can go on with their business, produce the work, commercialize it, release it, whilst respecting moral rights without you needing to waive them. And it's a misconception that one day you can wake up one morning and say, hang on, I gave you consent 2 years ago, but now I take it back and I use more rights to do that, to base my claim. That's a complete misconception. That would not happen. No judge would allow a performer to proceed on that basis. No lawyers would take that claim or make that argument seriously and in good conscience or in good application and respect of the law, because that is not what moral rights grant you. So you do have a minimum base level protection with thanks to moral rights that actually repeats or duplicate what is already good industry practice of crediting the performer where is reasonable at the end of a film, at the end of a broadcast, but that wouldn't be expected, for example, in where it's not feasible or practical. Often radio adverts is given as an example where actually naming the performer for an ident, so for something really short, for something as long probably as the two liners that were performed by the voice server, would not be reasonable or feasible. So there are lots and lots of places where the rights don't apply because an exception has been created in the legislature precisely to make them workable in commercial contexts and for everyone. So more rights are not as one-sided as their reputation leads us to believe, at least reputation in the field. And this is what I meant by the kind of surprise of the clash of culture experience, because lawyers know that. They're like, more rights, yeah, they're great. They're base level protection. They're not aggressive. They have caveats that mean that in practice, it will be rare to infringe them unless you're looking at a really extreme case of distortion or lack of attribution. But in the field, they're seen as this really innovation hampering or hindering right
Yeah,
when they're
I've never seen a contract that doesn't. The first thing in a contract is that I waive my moral rights. I've not ever seen a contract ever that says you can keep them.
And I think that's because of that reputation. And perhaps also kind of inheriting practices from waive all rights, etc., which are common when you're looking at things like a buyout or full assignments and waivers of all of the rights. And what is strange, though, and I've seen many contracts like the one Annette described earlier, where where the performers are asked to waive all of their moral rights, but later in a contract, the engagers have recreated an obligation imposed on them or bearing on them to attribute and the performer and respect the work. So they're recreating the rights contrarily into the contract after asking you to waive them in the first place, which for me is unnecessarily complicated. And I think speak to the fact that A, more rights are misunderstood, and B, that actually everybody's quite happy to respect them, because it's not in an engager's interest to have their work come across as mutilated or distorted or poor quality. So often the engagers and the performer's interests actually align. And the issue is managing perhaps third party behavior or misuse. But it's not in the engager performer relationship at this point, it's in the rest of the world engaging with the work relationship.
Well, speaking of the rest of the world, my question is this UK law based, or because you did sort of reference that earlier on, or are these rights that we have in work as it's delivered or recorded elsewhere?
So we do have two international treaties that provide more rights for performers whose work is fixed in sound recordings, and another treaty for performers whose work or performance is fixed in films. Now, those two pieces of legislation, for the first one from 1996, which is known as the WIPO, Performances and Phonograms Treaty, and just the title tells you phonograms, this is how outdated the language of the law can be. They mean sound recordings, of course, but nobody calls it a phonogram, I think, today.
No.
That sounds to be from the 1920s.
Wind up the Victrola. Yeah.
Exactly. So that first treaty was dates back to 1996 and still took about a decade to come into force. It needs to be ratified into countries, but it has over 100 plus countries ratified and signed up onto them, onto that one.
This is just in sound recordings, isn't it?
It is, yes. So the two more rights I've
Yeah.
described for performances fixed in sound recordings. Why just sound recordings in 1996 is because people gathering, the international lawmaking community, so all national governments coming together, are looking at the past basically and only playing catch up on technology, even though in 1996 we have films. And we have a thriving cinema culture and have been for decades. But if you want, they're playing catch up on the technological agenda and the needs of the creative industries. And it takes so long to have an international consensus, agree on the text, and see that text rolled out into national implementation. So in 1996, we're thinking about sound
This
recording.
sounds familiar.
Yes, right. And so 2012, we have the Beijing Treaty, and that's a treaty that brings more rights protection for performers whose work is recorded or fixed in films. 2012, right? We're talking about films, the same protection at the international level for film outputs. And this treaty came into force in 2020 during the pandemic and is therefore binding on countries for ratifications like the UK. And the UK is actively looking to make sure that its current more rights provision fulfills the needs and the obligation to performers who's worked in fixed in films.
I think we should specify what is meant by film, because the Beijing Treaty is the Beijing Treaty on Audio-Visual Performances. So
Mm-hmm.
there was the moral right was in just sound recordings, and I imagine that sort of partly that came from pressure from record companies and things originally. But when we talk about films, audio visuals, so really what this is doing is extending the right from just sound recordings to recordings that are synchronized with the picture. And that doesn't just mean cinema, movies, or documentaries. This could be a commercial, an explainer video. It could be anything where there's a voice and picture synced. That's the audio visual bit. So it was really strange that you had, well, in the UK, you have more rights and actually economic rights in a sound recording. But the second you add a picture to that, all those rights have gone. So this is an attempt to redress that. Is that
I
right?
think so, and I think actually when you point to those sort of, I was going to say niceties, but actually details is more accurate. It shows that the way lawyers and legislators think is divorced from practice. So they're thinking, essentially, I think when they're thinking performers fixing sound recordings or phonograms, they're thinking about musicians. And then they were like, ooh, but actors also work in audio, but they're not really like those kind of crossover of industries and of technology and of performance work were not really thought about. So they thought, well, let's look after musicians and then we'll get onto films slash actors later. I think that's the only way I can make sense of the fact that there are oversights or lack of clarity. Because when I read the text, about performances fixed in sound recordings, to me it also applies to voiceover work, even if it's integrated into film and becomes a soundtrack of a film. But it's true that typically soundtrack of films are not seen as separate sound recordings, so there are gray areas in interpreting the text, and the reason why we don't know how to manage those gray areas is that we have so very few case law on performers' more rights or those aspects of performers' rights, because it's expensive to go to court. And again, we go back to, why are we so worried about more rights? It's not like we have a buckload of cases where performers came to complain, before judges, or brought loads of lawsuits against their clients or their engagers. That's not the case. So I can't really explain this aversion to giving the protection to performers or leaving the protection with performers instead of asking for more rights to be waived so often. So yes, I think the really interesting overlap of work and technologies you've just described, Marcus, is not well captured in the law that has to parcel out different parts of performance work in a way that's a bit artificial. So if we think about the timeline, in 1996, we're thinking about performance and sound recordings. In 2012, we think about performance in film. My next question is, when will we think about performance in AI in relation to more rights, but also in relation to performers' rights more generally? I'm hoping this is happening, but before we have an international harmonization or an international agreement on that particular topic, and looking at the track record of similar work done with previous technologies, I'm a little bit concerned that will be slow coming, which is another argument to press on with good industry standards and to press on with national laws before we get that international agreement, rather than the other way around. Otherwise, we'll be out waiting for, I'm afraid, maybe, hopefully not, but a couple of decades.
Yeah, well, look, the Beijing Treaty was, I'm looking at it in front of me, 2012, and it comes into force 10 years later. And are we now in the UK? Because it's one thing to sign up, but to ratify it has to go through Parliament, doesn't it?
Yeah, the government's, yeah, well, Matil can say, but the government said they would when we left the EU,
And then, dun dun dun, yeah.
and they haven't. Although I noticed that there's another consultation open until mid-November. There's been one before, so I happen to know that Equity are scribbling away on that one.
Matilda, and Marcus, what are we being told? Are we being told, yes, of course, the UK is about to ratify any moment, or what?
Well, yeah, I mean, I think it was one of those things that went on the back burner. It's just as Matilda said many times, our rights, our sector is not remotely interesting to governments. It's just sort of it's not their day-to-day bread and butter stuff. So I don't know why, but the Beijing Treaty should have been ratified. Government promised to do it in 2012. They still haven't done it. And but I think now there are 47 countries that have. I mean, the reason it took until 2020 to come in was that in order for the Beijing Treaty to hold, 30 countries had to have acceded or ratified the treaty, and it took that long. It took 8 years for 30 countries to get their act together and actually do that. Um, so, you've said that moral rights. I mean, I'm just so used to waiving moral rights. I mean, I'm a bit confused by the Beijing Treaty in a way because I've still. I mean, it's kind of introduced moral rights, but in my experience, the first thing a producer is going to do is to ask you to waive them. But that's different from an assignment. So, I mean, can you assign your moral rights to someone else?
No, you can't.
And what does it mean as well if you assign them to someone else?
And what does that mean?
Yeah, no, that's a great question. I think those are all like kind of legal terms that lawyers are familiar with. So there are two types of rights. There are rights that are known as personal, and there are rights that are known as property, like, or proprietary. So a personal right is a right that you can't get rid of or assign. You may give permission to others to breach it, as in it's not a breach, it's an allowed use, but you can't sign it away. So think about rights like your privacy, and most human rights are rights that are personal to you that you can't get rid of, even if you try really hard, and even if someone puts a contract in front of you that says so. Just by law, they can't be detached from your person, and that's why we call them personal rights. Now, that means that you, by giving permission to someone else using a right that's otherwise yours and protected, you can waive them. So someone can ask you for permission to distort and mutilate your performance, and in order to do that without breaching your rights, they ask you for your permission, and that's often called a waiver. You're waiving that right for that particular use, for that particular project, for that particular person. It doesn't mean you're waiving more rights that may apply in relation to other performances, or that you're giving a blanket permission to anyone trampling your rights. When you're waiving your rights to with an engager, most often that only allows that engager to go on and use the work. It doesn't allow any other third parties not privy to disagreement to do the same. And often this is where it goes. You ask, you say, you want my moral rights? What for? Because my moral rights only covers extreme distortions of my work. Is that what you're planning on doing? If yes, okay, let's talk about that and let's see if I approve and waive my right. But if you're just going to use my work to edit, remix it, improve the sound quality, sync it with other work, then you don't need, I don't need to waive my moral rights for you to do that. That's already allowed under the law, and I'm consenting to this project, and by virtue of that, on you go. There's no need for more.
Yeah, I was going
Yeah.
to say, I mean, 'cause it's this waivability issue, but
Mhm.
doing some research, particularly about EU copyright directive and the Beijing Treaty, I was really interested to see that France, they're not waivable in France. They are they're a right you retain. And so, how does that work there?
So they're also inalienable, so they can't be transferred as well, so it's the same. And you can waive them in France. It depends what we mean by
Oh,
waiver. But what is happening, or is more common in France, is that you they monetize it. So they're treating moral rights in the same way as they're treating other performers' rights, like economic rights, because there is such a strong culture of moral rights in France that you don't have in the UK. And so producers and performers, in order to prevent, certain claims or performers complaining about the work and to be safe, they say, oh, will you waive the right for this and this use, and we'll remunerate you for that. And I think it'd be really interesting to talk about this topic with unions and representative organizations in France, because it is from them that I found out that yes, more rights are strong and they are waived, but against remuneration, and they were able to achieve that on a more regular basis compared to the UK, because the culture of more rights protection was stronger, was older in France. Something we should say is that actually more rights are often seen as rights coming from European countries, predating all of the international treaties, and that they kind of landed or got imported into common law countries like the UK later. And this may explain why we have a slight aversion and kind of reluctance to embrace more rights as this kind of odd recent transplant into our legal system. And often what you hear is that, don't worry, we don't need more rights because we have other industry practices and gentlemen's agreement. That means that the type of misbehavior or misuse of performers' work that you see elsewhere doesn't happen around here because we have other ways to deal with it. And that's partly true, but in the changing landscape, or the changing landscape of AI or with AI, I think it's interesting to revisit that statement and that statu quo, in my opinion, to see if actually more rights could play a role in that, in injecting a little bit more of a fair play contractually asserted in those gentlemen's agreements. Should I say gentle women now, gentle persons agreement?
Yeah, I mean, I suppose, yeah, well, in AI, moral rights really do come into focus because obviously when you're talking about what a third party can do, if you lend your voice to a platform and then that platform allows people to generate with text or whatever, they generate any content they like. Um, you as a performer don't really, you don't know what you're going to be consenting to. I mean, in the past, you kind of did. You'd read the script, you know what the project was. So, personally, I never minded waiving my moral rights because I thought, well, I know I know what's going on. I know the people involved, I know the project. But with an AI platform, I would have no idea how I was going to be misrepresented, and there are voice artists, many who have and that are friends of Annette's and mine who are on all the porn channels. They are on the fraudulent scam calls, and that's really puts completely different perplexion on the whole thing. I mean, it occurred to me that a lot of this. I mean, I was thinking about France, and I was thinking about sort of professional reputation, besmirching someone's reputation, how that, in the old days, people used to have duels, didn't they? They used to kind of, do you know what I mean? You would whack someone around the
Yes.
face with a glove and say, I'll meet you at 2 o'clock tomorrow afternoon with pistols or swords. And there's sort of a bit of that in it, which I kind of like. It's rooted in, well, I mean, defamation, I suppose. It's akin to that in a way.
Mm.
That's why these things are here. So, I mean, just a little bit more on that, on AI. Can moral rights help performers and creators to protect their work in the face of AI, or I mean, is it a grey area?
It is a grey area in countries where more rights protection is not strong. It keeps to the bare bone of what international treaties require, and the UK is in that category of countries that have gone with a bare bone implementation of more rights. But we're waiting for cases to confirm this, cases meaning legal cases, to see if in countries where more rights protection is higher and has a longer standing or longer running history of judicial decisions siding with the creator or with the performer for breach of more rights, whether use of AI on this type of content would trigger more rights protection. What's interesting is that in all of the things that are being looked at today to update the intellectual property framework to AI, more rights have come up and have been discussed. Whether they'll be retained as the way forward, I don't know. And, only time will tell. But it is seen as one of the tools which could be used within a range of other ones, legal, technical, and perhaps also educational, because I think there's a good deal of education that needs to happen on the part of performers, but also engagers and members of the public as to what you can and can't do with somebody's performance, namely their face, their voice, and their
Sure.
faces.
I have to say the two things I think that I'm taking away from this are a complete contradiction. One is that in one sense, moral rights aren't necessarily as scary as they look. I mean, the very term moral rights sounds really quite stern, quite old-fashioned in a sense, but it covers potentially so many things. But the other side of that is that they're not scary, but then again, they can be used for protection, but they don't necessarily give you all the protection that you think they might. So it is a bit of a kind of bundled up contradiction, but it is important. What I've taken, the number one thing I'm taking away, and I have got this on my website. So I have put my kind of terms and conditions on my website, and I do put that in the footer of every email. There is a link to my website, and those terms and conditions, including the reference to moral rights, that's there. And that's only there because I've spent so much time with Marcus Hutton and Dr. Matilda
Well, yeah,
Pavey.
I've done exactly the same thing. My terms and conditions are in my email footer, and they are in on my website as well. And I have, there is a set of terms and conditions, in fact, which give the option to waive or retain moral rights depending on the project. So yeah, I think it's important. I mean, we talk about these things, and I suppose part of the idea of these podcasts is to just kind of engage people with what's available to them, and why there's been this long history of creating these laws and creating these regulations, because they come from very, very long discussions. Because I think that performers have not been aware that they have anything, that there's anything there. And in fact, it turns out there are all these kind of treaties and statutes and laws being created that have come from years and years of pressure from creative rights organizations and from the music community, from the acting and film community, and kind of alliances of unions. And it's all been going on in the background. But I suppose if you're at the coalface, it's a bit like, there's a bun, I'm hungry, I need to eat it in order to survive. And people do, and I tell you what's interesting is that I know on my website, oh God, people are going to go start looking at it now. But because my
I know I did.
because my website tells me when someone's looked at something on my website, and I've had these terms and conditions up for quite a while now. Virtually no one has looked at them. So it's the same thing as when you buy an Apple phone or sign up to Google or whatever. People just do not read the small print. And I have to say, my terms and conditions were created by Equity, did it with a law firm over a year. Very, very fair to all parties. It's just sensible, practical stuff. There's nothing that it was a very, very carefully constructed template document, with lawyers and consultation with voice artists and actors and union representatives and everything else. It took a long time and was very expensive to produce. The law firm, in fact,
and I'm very grateful
Yeah.
because mine were created by going to Marcus Hutton's website and copying and
Yeah, well,
with permission,
with
lifting that
permission.
content.
I had his permission. I absolutely, I did, didn't I, Marcus?
yeah, no, in fact, well, no, it's just the Equity template contract. It's fine. It's there for members to use. But yeah. I mean, our contracts for years in the voiceover space, in the audio space, there were no. Well, I mean, there was the only contract was an email. You free at 10 o'clock? Here's the script, and that's it. Oh, and how much is it? And I'll pay you. Pay you in 30 days. That's been it. That's been the history of contracting for most of us. But more and more and more, the last year or two, contracts are appearing time and time and time again, and I've certainly heard voiceovers, and I've certainly heard people say, "Do you know what? I prefer the days of no contract, because these contracts are now much more onerous than I'd probably had more rights when I had no contract." Yep. Well, hopefully that's cleared up some things about moral rights. Has been informative about moral rights, but it's one thing to talk about them, of course. But what can we do? Well, we can assert our moral rights,
Yep.
and there are plenty of ways of doing that. If you're a voice artist, please go and look at the Equity template contract, because it tells you how to do that.
And before we wrap up, I think it's important that we add that while we're debating and exploring the ethical and legal issues around AI, we are not giving legal or other professional advice. We're sharing information and hopefully encouraging you to have the confidence to ask questions and assert those rights for yourself.
Absolutely. If you'd like to know more, please do give us a follow and a like on Instagram or X. You can just search for @LHV podcast, and you can let us know if there's a particular topic you'd like us to cover or a question that you'd like answered. Thanks for listening to The Last Human Voice.